Mr. Speaker.
I call the Honourable Minister, Christopher Finlayson.
Mr. Speaker, I agree with the previous speaker that the mercantilisation of the civil justice system is something that we should be very concerned about, and many of the problems that he correctly identified with respect, I think, are matters that can be dealt with by rules of court or judges actually taking control of a proceeding at an early stage. I don't know necessarily that statutory reform is going to deal with those issues. Having said that, however, there are a number of matters set out in this legislation that I believe will go some way to addressing that dreadful problem of mercantilisation, and the Minister has already referred to them. Mr. Speaker, I want to begin by acknowledging the outstanding contribution of the Minister of Justice in this monumental reform, and that's no hyperbole, because this is the most important review of our court statutes in over 60 years, and indeed the Judicature Act has not been reviewed comprehensively since 1908. And so she deserves the praise of every member in this House for what is a truly outstanding piece of work. And I want to acknowledge also the Law Commission and the Minister's excellent officials in the Ministry of Justice. Frankly, it should have happened in 2003 after the Supreme Court was created, but I regret to say the previous government was not up to it. But we have now a real Minister of Justice who understands these things and the importance of this work, hence this reform. Mr. Speaker, much of this reform deals with the issue of judges, and I just want to say a thing or two about our judges. As Lord Bingham, a now deceased but great former law lord in England, once said, the public entertain a range of views about the judges, and they're not always consistent, and they're not always favourable. 1 minute they're senile and out of touch, the next minute the very people to conduct a detailed and searching inquiry. 1 minute they're dinosaurs imposing savage sentences on hapless miscreants. The next, wishy-washy liberals unwilling to punish anyone properly for anything. Well, Mr. Speaker, I want to put on record that this country is very lucky to have a world-class judiciary, although sometimes they are subjected to unwarranted criticism. Some criticism, most recently in one of the Sunday papers, attaches to their remuneration, which is particularly unfair given that it's set independently. One can criticise judgments, but we've always got to be very careful to avoid personal attacks on judges, which are unacceptable. I also want to say that year after year, the vast majority of complaints to the Judicial Conduct Commission are found to be groundless. And I want to, at this moment, acknowledge Sir David Gascoigne and Alan Ritchie for the tremendous work they do as the Commissioner and the Deputy Commissioner. Many of the complaints to those two gentlemen are indeed malignant and vexatious. Still more are ill-conceived. And lately, we've seen vexatious litigants attempting to draw the courts in as parties to their own litigation, making targets of the justice and of the judges. And I want to say something about vexatious litigants in a minute, because that's a very serious problem this country faces. There are a number of matters that the Select Committee will need to look at very carefully. For example, Clause 93, which says the attorney is to publish information concerning the judicial appointments process. In fact, I've done that in relation to High Court procedure. It is transparent, but it's not well known. But now, as a result of the work that the Chief Justice and I have done, it will hopefully be much better known. The Select Committee is going to have a very good look at Clause 161, which deals with contempt of court. Contempt of court is set out in Clause 161, and there is a cross-reference to the other courts, for example, the District Court and the Employment Court and so on. Deals with a particular subclass of contempt in the face of the court, and that is a very serious issue. other work on contempt needs to be undertaken, and the Law Commission's looking at that issue now. There's also existing law, for example, on breach of suppression orders, something Mr. Goff knows a lot about because he was recently warned by the police about breaching suppression orders. I also want to say something very importantly on the issue of vexatious litigants, because there are so many more than there were now. Once upon a time in Wellington, there was one person who was sort of the Albert Haddock of the Wellington District Court. The New Zealand First member will remember that program from the late 60s, misleading cases. What we now have is almost an epidemic of vexatious litigants, which is why clauses 162 to 165 are so very important, because that will replace the existing vexatious litigants rule and insert these rules that deal with restrictions on either the commencement to a limited extent of a proceeding, an extended effect, or a general effect. And I hope the Select Committee takes a good look at this, because vexatious litigants are a problem and we really do need to do our homework on this particular issue. Mrs. Collins has also referred to clause 166 dealing with reserve judgments. That is in the context of the senior courts. It will also apply in other courts, and that is designed to ensure that the judges of all courts are able to ensure that judgments are given as quickly as possible, because sometimes the delays can be rather lengthy. And the other part that I certainly hope that the Select Committee takes a good look at are the rules relating to recusal of judges. Mr. Speaker, many of these provisions set out in what will be the Senior Courts Act are replicated in Part 2 dealing with the District Court, but I do want simply to refer to Clause 214 of Part 2, which deals with the appointment of acting judges. Again, this is an area where the Chief District Court Judge and I have recently agreed on a protocol. When I came to office, there were quite a number of acting judges, and what I've tried to do in conjunction with the Chief District Court Judge is narrow that number down, because there have been a number of attacks on appointment of acting judges, and the allegation basically is that in order to get a further acting warrant, they have to do what the executive wants. So it's inherently what one Scottish judge once called a cheap and nasty form of justice, and so I believe we should only have acting judges in very special circumstances. And that protocol on acting judges has now been approved. There are a number of consequential amendments to the Employment Relations Act and the Resource Management Act. The Honourable Minister has also referred to the recasting of the Judicature Amendment Act, one of the most critical pieces of legislation passed by this Parliament over many years, which sets out the rules for judicial review. We have rewritten it in modern English, and that too requires a good hard look at on the part of the Select Committee. So there is a lot here. I wouldn't simply characterise it as mere administrative reform. It raises a number of very important constitutional issues, but I do end by saying the Minister has done a fantastic job here. We can be really proud of this effort, and I do hope the Select Committee will turn this legislation around, because the package will be very good for the administration of justice in our land. Good speech.